Hi, it's Melissa from Worldwide Migration Partners. I'm a U.S. immigration lawyer and an Australian migration agent. Because I'm duly qualified, I often get questions from clients that have an Australian or a United States citizen spouse. Some of the differences in the two processes between Australian migration and U.S. migration are easy to explain. If you are trying to migrate your U.S. citizen spouse to Australia, the most important thing to remember is that there is a difference here between a de facto application and a married spouse application. For Australian migration, you don't need to be married to bring a partner from the United States. If you are doing a partner visa application in Australia and you're not married, that is considered a de facto application. The biggest difference between the Australian migration and U.S. migration for spouses is timing. For an Australian who wants to bring a U.S. citizen spouse into Australia, you may do an application onshore or offshore. While onshore applications may be the preference because you can be together during the processing, an offshore application may end up being shorter in time. A partner visa for a U.S. citizen can also be quite expensive. The filing fees for a partner visa for a U.S. citizen spouse are now almost $8,000. The timing for a partner visa for a U.S. citizen spouse now also can stretch into 24 months. When looking to migrate an Australian spouse to the United States, there are a couple of things to remember. One of the things to remember when you're trying to bring an Australian spouse to the United States is that you must be legally married before doing so. The United States does not recognize de facto relationships. The United States does recognize same-sex marriages. To bring your Australian spouse to the United States, you also have to consider timing. While it may be convenient for you to bring your Australian partner to the United States on a visitor's visa and then apply for an adjustment of status, we don't recommend that process. The safest and most efficient way for you to bring an Australian partner to the United States is to use an immigrant visa. During the process of an immigrant visa, most of the time will be spent overseas. One of the questions we get from clients is whether or not they can travel to the United States while their immigrant visa is processing. A foreign spouse may travel to the United States for short visits during the process of the immigrant visa. Before embarking on your immigrant visa process, we highly recommend that you contact us here at Worldwide Migration Partners so we can review your financial situation and advise if there's going to be any issues with your application. Because the processing times for an immigrant visa can vary wildly, it's important for you to get that information at the beginning of your application. There generally are 3 steps to an immigrant visa application. The first step to an immigrant visa application is filing an I-130 petition with USCIS in the United States. Once the petition is approved by USCIS, step 2 is that your application will go to the National Visa Center. Once your petition is sent to the National Visa Center, you'll be required to provide additional information. The National Visa Center will require additional information that may include taxes from the U.S. citizen as well as addresses from the applicant. Once all of the information has been cleared by the National Visa Center, you will be provided for a date of your visa interview in Sydney. Before attending your interview, you'll be required to attend a medical exam near where you live. For the interview, the U.S. citizen may or may not attend. That is up to you. At the immigrant visa interview, you may be required to provide additional information that was not captured by the National Visa Center. Once you complete your interview for your immigrant visa, the visa will usually be issued within the following 2 weeks. After your immigrant visa is issued in your passport, you may have up to 6 months to travel to the United States in order to validate it. Upon entry to the United States, at that moment you are considered a permanent resident of the United States. And after entry to the United States, your green card will arrive in the mail within a few weeks. If you click the box to receive a Social Security number automatically on your application, there is nothing further to do at that point. If you have been married for more than 2 years at the time of your visa interview, you will get a green card valid for 10 years. If you have been married less than 2 years at the time of your interview, you will receive a 2-year green card, normally called a conditional green card. It's important to remember if you receive a conditional green card, 90 days before the expiration of that green card, you should be applying for a permanent green card using the I-751 form. If you have questions about the 751 form or any other questions regarding the immigrant visa process, please contact the team here at Worldwide Migration Partners and we'd be happy to help you.